My name is Richard Eakins. I teach law at Oxford and I lead Policy Exchange's Judicial Power project with my colleague Graham Gee at the University of Sheffield. And one of the aims of the project since its inception really has been to improve constitutional understanding, helping non-lawyers recognise and evaluate the changing nature of judicial power and helping lawyers and judges better appreciate the dynamics of the political process. The Supreme Court's judgment in Miller last year, which a few of you will recall, provided a nice opportunity to discuss these matters. And the same seemed to us true of the other standout judgment of 2017, the Supreme Court's judgment in the Unison case. Judgment which of course has received, thank you now I'm probably audible, the Unison judgment received rather less attention, rather less public attention than Miller, but arguably is of more lasting significance. And like Miller, it's a judgment that's divided opinion amongst scholars and lawyers. And we're very pleased today to be able to publish Sir Stephen's critique of the judgment. As you'll hear, the critique is not a defence of employment tribunal fees in general, let alone any fee in particular. Instead, it's a paper that focuses on the way in which the Supreme Court came to its conclusion that the fees order was unlawful, and on the constitutional presuppositions on which that conclusion rests. And I expect our focus today, which our panel will take up in various ways, will be on the responsibilities of courts in relation to the rule of law and the constitutional balance more generally. And neither the publication of Sir Stephen's paper nor our discussion today would have been possible without considerable help from Amy Brereton-Simons, Christopher White, Ralph Buckle, Julian Mizzen or Dean Godson. And I'm very grateful indeed to them. Let me introduce those who will be speaking for most of our session today. And the eagle-eyed amongst you will have noticed that there are only 4 of us up here, not 5. Alas, Sir John Laws is unwell and can't join us today, which is a real shame. A very distinguished judge, as you know, with particular expertise and experience in relation to the questions we're discussing today. And I hope he'll be able to commit his thoughts and comments on Sir Stephen's paper to writing, and we'll publish them on our website in due course. Speaking first, on my left down here, Sir Stephen Laws, who was first Parliamentary Counsel from 2006 to 2012. Thereafter served on the Mackay Commission on the consequences of devolution for the House of Commons, and was a member of the advisory panel for Lord Strathclyde's review of secondary legislation and commons primacy. On my left here, Professor Anne Davies, Professor of Law and Public Policy in the University of Oxford. She's also the Dean of the Oxford Law Faculty, which strictly makes her my boss, although she assures me she's here speaking solely in a personal capacity. And Professor Davies is an expert in public law and labour law, author of 5 books so far, and many articles. And Lord Fawkes is a leading barrister, member of 1 Chancery Lane, particular expertise in negligence and personal injury and public authority liability. Member of the House of Lords since 2010, and from 2013 to 2016 served as Minister of State for Justice. So our order today, Sir Stephen will outline the argument of his paper, then Professor Davies and Lord Fawkes will comment briefly in that order. Sir Stephen will have a chance to reply, and then we'll have an open discussion, questions and comments from the floor. So, without further ado, Sir Stephen.
Thank you, Richard. Well, the paper's long and detailed, and I can only give you a taster now. But before I do, I should like to thank Policy Exchange and their Judicial Power project, Richard, for the opportunity they've given me to publish my views and to discuss them today. I spent a 37-year career grappling with the interface between law and politics. My reason for considering and discussing the Unison case is that I see an urgent need for each side of that divide to understand the other better. The Judicial Power project is an important catalyst for ensuring that the issues that engages are looked at, and for promoting the dialogue it requires. I very much admire its work, and I'm pleased to be part of it. So, to the paper. My premise is that there are policy choices for which political accountability is more appropriate and effective than legal accountability. On those choices, the political process should have the final say. Bad for our political and democratic system, and for the judiciary, to promote the idea that politics is more effectively done in the courts than in Parliament. Respect for both systems is diminished by that. The difficult question, though, is where the line between politics and the law should be drawn. My paper argues not only that the Unison case drew the line in the wrong place, but also that it manifested a lack of judicial understanding of important factors that are relevant to where that line should be. So So I want to spread a better understanding of those factors. I have absolutely nothing to say about whether imposing fees on claimants in employment tribunals is or is not a good idea. If politics and the law come to the same conclusion on that, my point is still that politics is the better way to get there. So first, the background. The Unison case was about the imposition of fees for bringing proceedings in employment tribunals or for advancing them to a hearing. The fees were fixed by an order made under an Act of Parliament by statutory instrument that had been given the affirmative approval of both Houses of Parliament. Another affirmative resolution order had designated employment tribunals as tribunals to be subject to power. The Supreme Court decided that the fees order was unlawful and void. The reasoning in Lord Reed's judgment is that the practical effect of the fees was to obstruct access to justice for claimants. The rule of law required it to be inferred that Parliament could not have intended that. The test that applied for deciding whether the order diverged from the intentions of Parliament was a retrospective strict liability test. It was based on evidence of the practical effect of the order since it had been made. Evidence showed that the introduction of the fees had produced a larger than expected reduction in tribunal applications. It was inferred that persons who found the fees unaffordable had been or would be deterred from bringing or continuing proceedings to enforce their legal rights. This quite expressly is not a decision about a defect in the process of making the order. It's a case asserting the right of the courts to second-guess the policy after its implementation with the benefit of hindsight. The practical effect of the court's decision was that the fees held to have been unlawfully levied had to be repaid. In practice, a sum running to several millions of pounds, a very large sum, 30 million I think was budgeted for it. I was told just before we started that rather less than that has so far been reclaimed. A very large sum of money has to be dispersed out of public money in windfall payments to people who have not, in the Supreme Court's terms, been denied any access to justice. Anyone who had been deterred from bringing or continuing a claim, having paid no fee, had no entitlement to a repayment. Instead, the principal beneficiaries of the repayment scheme are unsuccessful claimants, their trade unions, and unsuccessful employer defendants. Unsuccessful parties are the main beneficiaries because it had become the practice of tribunals to order successful claimants to be reimbursed by the unsuccessful ones. There are two ways in which this immediately draws attention to factors relevant to where the line should be drawn between legal and political accountability. First, there's the failure to appreciate the fundamental nature of policy making and its legislative implementation. There is always an inherent element of unpredictability about whether legislation will achieve its intended effects without creating unacceptable adverse consequences. It makes no practical sense for it to be unlawful to risk unexpected consequences when implementing policy or legislation. When legislating for policy, there is always a balance to be struck, involving what can only be political judgments about the value of the intended policy effect, the acceptability, nature and likelihood of the risk of adverse consequences, and the management of that risk. It's not only because there can never be certainty about how complex systems will respond or adapt to change that there is always a risk. It is also because it's in the very nature of law that it's about applying accessible and predictable rules to cases defined in clear but necessarily general terms. It's not practicable to deal in general terms with every possibility of an unexpected effect or hard case without granting discretion so wide they would themselves be questionable in rule of law terms. It's the rule of law that also requires that those to whom the law applies should not be subjected to obligations which make it impossible to predict what conduct of theirs will be lawful. Nor should the law impose requirements with which it is impossible to comply. Those principles are equally applicable to rules created by the courts for the making of legislation by legislators, or at least in my view they should be. The Unison case, however, contravenes the first of these principles because it fails to provide any clarity or predictability for the legislator about how the power conferred by Parliament could lawfully have been exercised. And Parliament must have intended the power to be exercisable somehow. It also fails the second test, in theory as well as in practice. The Supreme Court accepted that the power to fix fees could legitimately be used to incentivise the earlier settlement of disputes. That, it seems, was within the intention of Parliament. Nevertheless, achieving that purpose is made logically impossible. You cannot incentivise an earlier settlement without disincentivising either the bringing or the continuation of the proceedings in the same case. They are different sides of the same coin. The second matter, obviously relevant to the line between law and politics, is whether the law can provide an appropriate remedy for the issues that it arrogates for determination by itself. In the Unison case, striking the policy balance in what the court found had been the wrong place produced a remedy that did nothing for those affected by the perceived unlawfulness. There are other respects in which the Supreme Court seems to have misunderstood or disregarded factors that are relevant to the line between political and legal accountability. These are mostly aspects of the sadly quite common phenomenon in which a complex system-based problem is determined by reference to the one aspect of it that can be isolated and framed as a legal question. The result is that the resolution of the main policy issue is settled by an oversimplified proxy question and without the appropriate consideration of its full context, without the system-based approach which could be part of its resolution in a political forum. I give some examples of this in the paper. One example of this is how is the suggestion in the judgment that the effectiveness of policy and of law can be meaningfully assessed by reference only to evidence of what happens in the justice system. Policy is always intended, even policy about court fees, to have its principal effects in cases where there is no resort to litigation. There is the way in which the judgment equates the concept of access to justice with the idea of access to litigation. Those are not the same things. That false assumption leads to a disregard of any justice impacts of the fees order on parties to employment litigation other than claimants. And finally, and crucially, in the context of the need for a political systems-based approach, there is a worrying failure to address the fact that the policy to which the case related was essentially about how to fund a public service and about priorities in the distribution of public funds, and included the question about the extent to which public services should be funded out of general taxation or out of cost recovery systems. Public expenditure issues are not suitable for judicial adjudication, both because they are too multifaceted and their knock-on effects across the whole of the public sector so widespread, but also because they are too political. Funding allocations and priorities and the ring-fencing of services for funding purposes are often the centrepiece of electoral politics. We have an express statutory provision in which Parliament has specified that the NHS should be provided free of charge at the point of use. The question I ask is it appropriate for a similar, necessarily competing principle to be created by the judiciary for the Employment Tribunal Service? The final part of my paper deals with a more conceptual and perhaps more academic issue, but one I infer may have informed the other aspects of the judgment which concern me. It's certainly an issue that is also highly relevant in practical terms to where you draw the line between legal and political accountability. An analysis of Parliament's role in the Constitution involves a serious misconception if it focuses wholly on Parliament's role as a legislature and the enactment of primary legislation. Our system, unlike the theory of some other states, is not one that provides a rigid separation between legislative and executive power. Parliament has a very important role in relation to legislation, a dominant role, but so too does government, which always has in practice the initiative, as well as a veto power which is equivalent to that exercisable by either House of Parliament. Parliament's role in relation to primary legislation and its influence over it is significant, but the discharge of that role is only one aspect of its wider role of scrutinising government policies and of calling government to account for the effects of implementing them. So when Parliament does legislate, it's typically doing so to give constitutional validity to specific proposals from government, rather than, as the judgment suggests, to set up in a relatively abstract way the broad parameters of the overall system within which all future activity by a separate executive should be carried out. Legislation needs to be construed accordingly. One important aspect of this is that it is a mistake to draw an artificial distinction between Parliament's role in relation to primary legislation and its role in relation to secondary legislation, like the fees order. The difference between them is only one of degree. Parliament has both formal and informal supervisory powers over secondary legislation, and in practice as much influence as it chooses, and it's not for the courts to question how its choices in that respect are exercised. Furthermore, when Parliament provides for an issue to be subject to affirmative resolution procedure, as it did in this case, it is expressly asserting that it believes that the question the resolution answers is one for determination by political rather than legal mechanisms. So those are some of the issues I raised in the paper. I hope you think they're interesting and worth discussing, and whether you agree with me or not, think that they are worth discussing. And if so, there's a much fuller discussion of them in the paper.
Thank you very much indeed. Thank you, Richard, for the invitation, and thank you to Stephen for a very stimulating and thought-provoking paper, which I would strongly encourage you to read. I think I disagree with almost everything he says, but that doesn't mean that I didn't very much enjoy reading it. So I'm just going to pick out 3 points that I think are quite crucial to Stephen's argument. And the first of these, I think he perhaps didn't quite highlight in his summary, so this is something that you'll have to look at a bit more closely in the paper. So in his detailed analysis of the judgment, he makes the point that the Supreme Court's decision is retrospective. It looks at the effect of the fees order rather than at what could have been foreseen by the Lord Chancellor when it was enacted. And of course that's a sort of superficially attractive point in some respects, but what I think it misses out is that this is a case about common law rights. So the question isn't whether the decision maker followed a proper process, but whether rights were infringed. And obviously you'd hope that following a proper process would make an infringement less likely, but it's no defence if an infringement actually takes place. So in this particular type of case, it's the effect that matters. It's not a case about process. It's not a straightforward, old-style natural justice judicial review. It's a case about whether rights have been infringed, and that fundamentally requires looking at the effect of the decision. So that's my first point. Second point, it is Stephen's suggestion that there is no way that the Lord Chancellor could have come up with a scheme that would have been lawful, or that there's no way for the government to do so now. Obviously it's in the nature of judicial decision making that you strike something down. It's not the judge's job to come up with alternative solutions. That's for politicians and clever policymakers in government to do. So I think that we need to think carefully about the judicial role here and not criticise them for things that they really can't do. But I think it's important to note that the Supreme Court's test wasn't does the scheme hit the optimal price point, which is something that Stephen argues in the paper, but is the scheme proportionate? So does it recoup money from tribunal users without denying access to justice? And sadly, from my perspective anyway, I think there are quite a lot of pointers in the judgment as to how the government might be able to put in place a fees regime for the employment tribunals that would not fall foul of the Supreme Court's concerns. And of course, there's always the broader possibility of doing this through primary legislation, which I still think anyway the courts would not be able to do a great deal about. Where I think Stephen's at his strongest in the paper is on his point that the Supreme Court is getting quite stuck into an issue of resource allocation. And I think we all know that the Ministry of Justice's budget situation is very challenging. Money not recouped from tribunal users is money lost to that budget. And of course he's absolutely right to say that the courts don't see the full implications of the cases they decide. They aren't well suited to deciding how best to allocate governmental resources. That is a political question for government, parliament and the electorate. But two things to say about that, one of which I suspect some of you won't like very much. You might not like either of them. So lots of judicial decisions don't look as if they allocate resources, but they do. It's very difficult actually to make judicial decisions that don't at some level involve allocating resources. If I go back to my example of your sort of classic natural justice kind of decision where you quash a government decision because a proper process hasn't been followed, the decision maker has to go back and take that decision again, and there is a cost attached every time that happens. So any judicial decision at some level allocates resources. My second point, courts only have in this country at the moment a limited range of rights that they can enforce. And my view would be that if they were let loose on a greater range of rights, including socio-economic rights, they would have much greater sensitivity to the complexities of resource allocation with which they might then be engaged. And so paradoxically, keeping the judges away from these rights might tend to imply that the civil and political rights that they do have the capacity to enforce don't have resource implications when they very clearly do. That was the one I thought some of you might not like. I think Stephen wasn't liking it too much. So look, upshot, I think Stephen's absolutely right that the courts do need to be careful in this area of resource allocation, but I don't think there's anything wrong with them setting some boundaries, and I think that is what they have done in this decision in unison. Thank you.
Thank you very much, Richard, and once again, thank you very much to Policy Exchange for promoting this very interesting debate. When Richard asked me to take part in the panel, I'd only read a brief summary of the decision. I thought that if I read Stephen's paper before reading the full judgment, it might cloud my objectivity. So I came to the judgment as a jobbing barrister with a great regard for the rule of law, of course, and access to justice. But perhaps of more relevance, as a former minister at the Ministry of Justice. I wasn't in post when the order was made, but I did stand at the dispatch box for the best part of 3 years, taking a considerable amount of political heat about it. And I also remember it being a key part in the 2015 election of the opposition's argument that we were denying access to justice. So the order was very much a political issue. Rather than follow Stephen's excellent analysis, I'll stick to my own rather primitive analysis of the judgment. The judgment does acknowledge the fact that the decision to charge fees was a political one. It was going to help some employers, particularly small employers, to deal with what could often be vexatious claims, and it was going to save the ordinary taxpayer some money. On the other hand, for every vexatious claim, there was a risk that genuine claims would not proceed because employees could not afford the fees. A fee remission scheme and a discretionary power to the Lord Chancellor was intended to mitigate that. Now, it's quite clear the Supreme Court didn't like the policy, but unlike the lower courts, they felt able to conclude that it was unlawful, and the result was a catastrophe for the government. Fees had to be paid back, whether it's 30 million or less, and the system reverted to the original arrangements. A big political hit was enjoyed by the opposition. Now, the basis of the Supreme Court decision was that there was a right, variously described as the common law right to access to justice, or the constitutional right of access to justice, which it was said was inherent in the rule of law. Now, I'm sure we can all agree that it's highly important, although it's always been a bit of a theoretical right, because there's rarely, if ever, an entirely level playing field where justice is concerned. But Lord Reid, with whom the rest of the court agreed, said that the courts, quote, do not merely provide a public service like any other, close quote, and he emphasised the unique nature of the right. Is it really more important than any other right? And are we lawyers not in danger of rather over-romanticising this important factor? And of course, he referred to a number of cases, the importance of cases getting to court, as Stephen said, including Donoghue and Stevenson and the like. Where is the right? It's in the Constitution. We must fail to find it somewhere. Well, Lord Reid certainly gave us a rousing recital of great constitutional hits. He began with Magna Carta. I've always been a bit worried about Magna Carta. When I shared a house with a journalist who used to write leaders for the Evening Standard, and whenever he was criticising anything legal, he always used to refer to Magna Carta without any very more, just mentioned it. I asked him why he did that. He said, well, it's to give spurious authenticity to my prejudices. Anyway, we get Magna Carta. We had Sir Edward Coke in the 16th century, Blackstone in the 18th century, before he rushed on to the middle of the 20th century. One of the difficulties I have is that there was not, in fact, a denial of justice here. It was simply too expensive for many dismissed employees. Now, the very careful judgment contains a good examination of the history of tribunals, the development of the policy, and, of course, an analysis of how the policy worked in practice, drawing on a great deal of evidence, and in particular what was described as the review report published by the Ministry of Justice. And that report was quoted and relied upon by Lord Reid. He said the fall in the number of claims has been so sharp, so substantial, so sustained, etc. And he reviewed the whole of the evidence and came to the conclusion that it was unlawful. Now, I was slightly troubled by one aspect of the case, which is that there was an argument which is referred to at the end of the judgment, where I think the beleaguered Lord Chancellor's representatives, realising they were going to lose, said, well, it probably wasn't unlawful at the beginning, but perhaps it could be argued that it became unlawful when there wasn't a sufficient response to the evidence, and therefore that was unlawful. Perhaps we can have a declaration that it was unlawful, i.e. giving the government a chance to change things. That puts a much more subtle argument, very, very crudely. But Lord Reid was rather firm about that. No, no, no. It was a unlawful ab initio, i.e. from the beginning. And yet the basis of the decision was clearly the fall in the number of claims, that it was so sharp, so substantial, and so sustained. Now, I pose the question, what if there'd been a slightly less dramatic fall? What if it had been only 50% or 70% or something less? Would that have made the policy all right initially? Surely what the courts were doing were effectively looking at how the policy worked out, relying on that evidence, and then saying, looking back, it was void ab initio. I don't find that a very satisfactory way of approaching this. Now, judges, of course, don't have to balance budgets or face elections. And it might be said that this really is a case of judicial power, the very focus of the project we have. And some of you may remember the observations made by Baroness Hale about that there should be some political element, perhaps, in the appointment of judges. It received a very sniffy response from the judicial legal community, it has to be said. But perhaps she's right. If judges are going to take what is, I think, academic lawyers took a polycentric approach to quite matters of fees, perhaps we need a written constitution like the United States and a British Bill of Rights with a Supreme Court that has a clear constitutional mandate. The Human Rights Act has, of course, empowered the courts to decide matters they did not decide before. That was, of course, Parliament's choice, not the judges. But with Brexit clogging up Parliament for the foreseeable future, perhaps we should hand over to the Supreme Court the power to make all our laws, or at least government could run their policies by them before we launch them. Should judges decide court fees and budgets, or who gets legal aid, or is that a matter for government? Now, interestingly, the Bark Commission, which was commissioned by the opposition, was asked to look into the whole question of legal aid post-LASPO, and came to the conclusion that these matters should be controlled by a Quango, a Commission for Justice, but that judges should have a great deal of control over who got legal aid. And we really are going to stray into territory which is pretty novel, without any obvious constitutional justification for doing so. It seems to me that it's not just indigent claimants who might say that their access to justice has been prevented. What about the media, were Section 40 to be brought into force? What about insurance companies if quacks continue? The quacks arrangement means they have to pay even if they win. These are intensely political issues, and it's for politicians to be accountable for them, just as I was accountable standing at the dispatch box. We have excellent judges in this country. Let them keep out of politics.
I should say that Sir Stephen's paper is either on our website now or will be by the time we finish today. Sir Stephen, would you like to say anything in response?
I don't have very much to say, and I'm afraid not much at all to say to your folks who I'm happy agreed with most of what I said. I was a bit worried when he was making some suggestions about how we could improve things that he was serious, but I realised at the end that he wasn't. And that comes back to the second point that Anne Rae was about, or her third was about the budget implications of the decision. And I think the reductio ad absurdum that Lord Hawkes engaged in is really relevant there. Here was a decision that resulted from an Act of Parliament that conferred a power to fix fees. There was an affirmative resolution, a vote in both houses, to provide that those fees could be fixed for employment tribunals. There was a further order which, because it was imposing fees on something that hadn't previously been subject to fees, had to be affirmative resolution that decided what the rate of those fees should be. That's a lot of parliamentary involvement. Supposing the Ministry of Justice wants to close a court or to reduce its staff, that has implications for the access to justice of the people that use that court. Is that something too that can be litigated up to the Supreme Court? Because that's the implications of this judgment. I just wanted to say two brief things about Anne's other points. I mean, she's right that if you define this as a common law right and the effect is relevant, you get to the position where you wait to see what the effect is, and then you decide whether you're retrospectively going to invalidate the order you made. And that's what the Supreme Court decided. My point is that if that's the way we judge policy, it becomes more or less impossible to legislate in any way that gives you any confidence that what you're doing is lawful. And she's also right that the judges didn't say specifically that you had to find the optimal price point. Another view is that what you had to find was the proportionate amount. But all of those are Goldilocks tests. You have to find the answer that is just right. I was involved with legislation for very many years, and at one point I said that trying to hit the target in legislation is like trying to hit a moving target from a moving platform. You never know what the implications of what you do is going to have be. A lot of, if you look at the history of legislative change, a lot of it involves trial and error. You quite often need a ranging shot in order to hit the target. That's the way politics proceeds. And to make that impossible does what I think is the mischief in too much legal involvement in politics, is it reinforces the status quo. You don't change, the thing that the law always guarantees is that people who've got something can keep it. It doesn't give people who have a hope of something better any right to it. And that's why we need a system that allows legislative change. I think that's all I want to say at this stage.
Thanks, Steve. We have some time for questions and comments, and we have time for our various panellists to say a few more words about what's been said already. And I can see a host of hands, and I think a microphone's being found now. Certainly is. Okay. Gentleman here, so Jan Pottersmith. Sorry, I'm going to point my head.
Jan van Zijl-Smith, Bingham Centre for the Rule of Law. My question concentrates on some points made by Sir Stephen towards the end of his paper when he talked about this being delegated legislation where Parliament had some role and indeed had to vote it through on the affirmative procedure. Now, it strikes me that the proposal that the court should step back in these situations is really taking us towards an all your eggs in one basket constitution. Now, already in comparative terms, the UK Constitution allows fairly limited judicial review, not of primary legislation, only of exercise of public power by the executive. And if we look at what actually happened back when SORDA went through, there were really impressive evidence-based arguments marshalled, or rather economics-based arguments grappling with the issues. They were met with just a firm stance of the government. And of course, being delegated legislation, there was no opportunity to peel off backbenchers from the government through amendments. It was an order that was take it or leave it. So it just worries me where that argument is taking the Constitution.
Thank you. Well, Stephen, you want to start and then see what we've got an answer?
Yes, I mean, I think there are two separate issues, which is, does Parliament look at these things properly? Is the excuse for this sort of approach that Parliament isn't doing its job? And as you rightly say, it definitely did do its job in this case. Falk spent 2 years, did you say, defending it. There was a massive inquiry from the Commons Select Committee that looked into it, looked at all the evidence based. It may be that process didn't produce the result that you, or maybe I, think was desirable, but it was a proper political process. And there is always this non sequitur that occurs, and it's part of the sort of non sequitur that occurs in the judgment, that people assume that if the government isn't defeated on something, Parliament has no influence on it. That's not the way things work in practice. And I want, again in this room, to draw attention to the research in Meg Russell and Daniel Gover's book on legislating at Westminster, which is a massively impressive book. It was published towards the end of last year, which does a lot of quantitative research into the influence that Parliament has over legislation. And what it showed is that Parliament has enormous influence over legislation because of the factor that there is invisible influence. Government doesn't propose things to Parliament it doesn't think Parliament is going to agree to, except at the moment, which is why politics appears to be such a mess. But the mess we're in at the moment really proves how the system normally works, which is you say the mind of the government couldn't be changed. The government wasn't putting anything to Parliament that it didn't think Parliament would accept.
Yeah, I mean, the point made in Stephen's paper about the fact that it's fashionable now to decry the statutory instruments, and we're certainly getting a great deal of that during the passage of the withdrawal bill at the moment. There is an argument that really we should do away with statutory instruments. For example, the whole of the corpus of law, which is going to be defined as EU retained law. There's an amendment which suggests that should be considered as primary legislation, and that we shouldn't have statutory instruments. And there's a great deal of criticism made of the whole process. I think the answer is there is a variable degree of scrutiny according to the statutory instrument. But Stephen must be right. By the time a piece of legislation giving power to the minister in appropriate circumstances, and that may be questionable, to make an executive order has come before Parliament, there's been a great deal of preliminary work. Now, you may not agree with the outcome, but it's not in a vacuum.
I think for me it's really what I said earlier. What matters here is the effect of the policy, not the process.
We really can't hear anyone in front of the room.
Sounds like you're live.
Is that working now?
Okay.
Sorry. So I was just reiterating what I said earlier. Really, what matters here is the effect and not the process. Having a good process doesn't serve as any kind of defence when we're looking at the effect of the policy that's been implemented. I suppose the other point I'd make is that I don't think it's a recent fashion to be concerned about the level of scrutiny of statutory instruments. That was certainly the fashion and had been for some time when I was an undergraduate, which is quite a long time ago now, so it's not a novelty.
Law in the making was in the 1930s.
Exactly, yeah.
I can see a host of other want to ask questions. Two up the front here, and then gentlemen at the back. If we can take three at once, that'd be very helpful. So it's Joshua Rosenberg here and Lord Brown. So if we could.
Thank you. Yeah, Joshua Rosenberg. Stephen, you say in your paper that in a real-world constitution, the main function of Parliament is to bestow constitutional legitimacy on the policy and other actions of the executive. And you say that the Supreme Court had misunderstood the collaborative relationship between the government and Parliament. If that's so, and if Parliament and through Parliament the government has the last word, then what's to stop the government simply overturning this decision by the Supreme Court and implementing the policy that it wanted to in the first place? And as for saying, well, you know, it's a moving target and we don't know what the right level of fees is, otherwise it might be overturned by the Supreme Court again, as you're implying. Well, zero is okay, £1,200 is too much. Surely it's possible for the government to find some figure between £0 and £1,200 for an employment fee, which the courts would find acceptable.
Well,
let's take a batch of three if we may. So hold your thoughts, Stephen. Brown.
Simon Brown, once a judge. My question is provoked really by Anne Davis, but it relates also to what Joshua's just said. The suggestion here is that if this had been done by primary legislation, the courts would have been powerless. Not so. This was found to be a breach of the common law and of the Human Rights Convention and of the Charter of Fundamental Rights. And under that charter, the Supreme Court would have been empowered to disapply that primary legislation. For my money, that's an extremely troubling matter, and I am strongly against the incorporation of the Charter now into domestic law as we go through this withdrawal bill. But don't deceive yourselves into thinking that all Parliament has to do whilst the Charter remains in force is to pass primary legislation. Not so.
Thank you. Last question in the batch of three is gentleman in white back there. Last one's turn.
I'd like to ask Anne, given that all government policy has socio-economic effects, what is it exactly you think the rest of us should be allowed to vote on and politically determine? It's not quite clear to me what is the dividing line for you between issues that should be determined democratically, politically, and those issues that should be determined by judges interpreting human rights and other legal concepts.
I'll start with that question, Anne, and we'll go back.
Do you want to go back down?
Okay. Stephen, you begin.
Well, could the government find a right answer? Well, possibly. I mean, I came to this because I read the judgment and then I read it again, trying to work out if I were trying to draft the order, how I would find what the right answer was, and I just couldn't. And the practical effect of the judgment is, I mean, what do civil servants call ministers? A very brave minister. It would take a very brave minister to say, having taken the bloody nose from the Supreme Court on this, that they wanted to have another go with a different figure. So the practical effect of this judgment is, quite apart from the European and Charter implications, that the power to fix fees for employment tribunals is a dead letter. Don't rule it out entirely, but that's its effect. And the question is that effect that the Supreme Court ought to be able to produce? And I agree with Lord Brown. The judgment had other aspects of it that were not to do with common law illegality, which you can look at wholly within the system of UK constitution that did have other reasons for it that would have applied even without that. My argument is against extending those, I agree, undesirable consequences to some common law rule that will then survive and give the judges the power to overrule political decisions on matters where political decisions are more aptly the way of deciding things.
On the question of fees, it seems to me that's preeminently a matter for a statutory instrument. As soon as you put it in primary legislation, which you can't just change just like that, it's bound to be out of date. When we had rampant inflation, it was almost immediately out of date. Not quite so much now, but it's bound to be inappropriate. I just don't think it's practical to do that. Lord Brown's point about Europe, in fact, it was pleasing that the Supreme Court did in fact grasp the nettle and decided on common law principles. The reason the EU came in at all, as I understand it, was that at the lower courts they'd identified certain principles of employment law which came from Europe. Therefore, it was said that as a matter of European law there was a potential involvement of Article 46 or Article 47 of the Charter of Fundamental Rights. Since there wasn't any case law, they were allowed to incorporate the case law from Strasbourg. The result was that they didn't need it to come to the conclusion that they did. But it's interesting that creeping into their analysis on common law were some concepts like our old friend proportionality, which owes its origin to EU law, and indeed the idea that if you're going to interfere with or restrict rights of access, it has to be minimal. Those are matters that are now coming into the common law via Europe, and I suspect after Brexit they will remain. I think that was all.
Firstly, on the dead letter point, the government itself has said that it doesn't regard the power to set fees in the Employment Tribunal as a dead letter. We'll wait and see what happens about that. Simon's absolutely right about the possibility of disapplying the statute under the Charter. I suppose I was trying to get my head around the forthcoming new order and getting slightly ahead of myself. And on the human rights question, that needs a book-length answer, which I think Richard wouldn't thank me for just at this moment in time. But I mean, I think what I would say about that is that it is for courts to set some outer boundaries which involve protecting rights, particularly of people who might not get very much through the political process because they are minorities of one sort or another. And then that leaves plenty of scope for policy to be made within that.
Do you want to come against it?
Yeah, well, can I come in at one point on the European stuff? Because I mean, I did read Lady Howe's judgment as well, and what struck me about it was how the analysis for European purposes was wholly different from anything that would have been going through the minds of anyone involved in fixing a power to fix fees or fixing fees themselves. And it struck me that the judicial world is in a completely different box, which is why I think what's required is more dialogue between the two. Entirely different box from the executive and parliamentary world. If you're asked to provide for provide a power to fix fees, you know that if it's fees, it's going to be a cost recovery system. If you're not imposing taxation, you are taking any power to recover costs. When you come to exercise that power, what worries you is whether the fees you fixed involve any degree of cross-subsidisation, so that you would worry about whether or not someone was being charged a fee larger than is relevant to what they are getting for the fee. Lady Hale's version of working out what the best fee is, the one that is most efficient for recovering the most for the judicial system, that's not a fee recovery system, that's a hypothecated tax system, and this is 100 miles away from that.
We'll take 3 more questions. There's a gentleman back there, and if you catch my yes, sorry, so wave his hand there. Second, thank you. First question.
Hi, Steve Hines, Legal Action Group. A comment and a question. The comment being, we're here because £1,200 was so bad it engaged common law principles, it breached constitutional rights. There's a simple answer. You set the fees at the county court small claims limit. These are cases that aren't worth, on average, something like £4,000. So there's your answer. The question that stems from that is, do the panel accept that there are going to be common law constitutional principles that sometimes trump legislation, whether it's secondary or primary?
Thank you. And another question over here. Thank you. Anyone else wants to add themselves to the queue, then wave your hand to me.
John Holbrook, a barrister. Is the source of this problem political or legal? Because I think, Stephen and Edward, it's implicit in your arguments that you see it as legal, in the sense that you think the judges have exceeded their rightful powers. You think they've made bad decisions. I would suggest to you the problem is really political, in the sense that judges are actually only using the tools that Parliament has given them. And you can see that in the Unison case with the alternative reasoning, which came from Lady Hale but was supported by the other judges, on discrimination law, which is straight out of statute. It's all there in the Equality Act. If you give judges powers to decide that a measure is disproportionate, you can't grumble when judges conclude that a measure is disproportionate. The solution is to take those tools away from them. And that means looking at this problem politically and repealing lots of this legislation so that Parliament can reassert its political primacy.
Thank you. And man in the orange jersey there. Well, front right, orange, brown. You know who you are.
I'm Joe Vestron from the Public Law Project. Both Lord Fawkes and Stephen referred to the political heat around matters, whether it's in the manifesto, what position it occupies in the government's platform of the day, as a potential guide to whether something is political or legal. And I wonder whether that's really a good guide as to whether something is political or legal, or whether, because that's so dynamic, could a government make something less justiciable by putting it higher up their policy agenda? Likewise, could an opposition weaken the claim by making it more part of their platform?
Very good. Steve?
Well, on the last point, I don't think something's not in the manifesto if everybody agrees about it. I don't think you should have something that is not political because all political sides are agreed that it's the right thing to do. It may still be a political issue. It doesn't have to be controversial to be political. It needs to be determined in a way that takes account of factors that you can't take into account of when you're making a judicial decision. Is it legal or political? Well, yes, in a way, it is. I mean, you're right. I mean, I think discrimination law is there. I didn't discuss the discrimination side of it because it is there, and the courts had to decide it in accordance with it. But discrimination law is very much subject to the same sort of objections that I'm making, which is if you're legislating to produce legislation that conforms with discrimination law, you haven't the faintest idea whether what you produce is going to be right or wrong, because discrimination law is not confined to making sure that everybody is treated the same. You have to treat the differences between people in a proportionate way so to not discriminate. And you cannot predict all the differences that will be treated relevant when you get to the court. So discrimination law is there. I don't think that it follows from that we can't complain if the judges choose to extend it to areas that Parliament hasn't entered into. And on the question about whether Parliament has no limits, I'm afraid I'm an unashamed believer in parliamentary sovereignty. I believe that if that what parliamentary sovereignty means, that in the last resort, which I think is true, in fact, even in systems with written constitutions, in the last resort, politics can always trump law. You may have entrenched provisions that require more difficult politics to trump the law than you do for other things, but in the end, all constitutions end up with the fact that they can be changed by politics.
First point was, should they have made the fee a bit cheaper and it would have been all right. It's true that the judgment does refer specifically to county court fees by way of a comparator. And the answer is it might have been less likely, but it doesn't seem to me that it would make it immune from challenge. Second point from Mr. Holbrook about, well, is the problem really that we should be legislating more carefully to avoiding giving judges this sort of room for manoeuvre? That doesn't misrepresent what he was saying. But of course, under the Human Rights Act, the Parliament gave judges an enormous amount of power. They may not have welcomed it, but they were effectively having to make various decisions which in many eyes would have been considered quasi-political. And quite a few, the Equality Act likewise gives a certain amount of freedom. I think Baroness Hale's judgment in this case was far more based on statute. But in fact, Lord Reid, more based on statute, but Lord Reid, on the other hand, was facing quite clearly the acknowledgement of a common law right. Now, what does that common law right mean? The right to access to justice. Any government now is going to have to be advised by their lawyers that if they are doing anything about access to justice, do they fall foul of this common law right? That's an assertion by the courts that they have the power to challenge it if it does not satisfy their concept of a common law right of access to justice. As to the question about if you put it in the manifesto, do you take it out of the judge's hands? I think that's putting it a bit too high. My point was, perhaps not a particularly legal one, which was that it was an illustration of how political it was and how dangerous it is for judges to step into those waters when they aren't controlling budgets, they're not taking the political hit, and they're not accountable.
So I think, just two comments, I think we live in an interesting time for common law rights. I think it's very interesting that Lord Reid chose to emphasise those, and I think we will get some more answers over the next few years to those questions about what effect they have, particularly in relation to primary legislation. So I think, yeah, we'll see what happens about that. I just wanted to pick up on one thing that Stephen's been emphasising quite a lot, which is the question of predictability for the government. And I can see that it must be absolutely exasperating to have spent a lot of time thinking about a policy and you enact it and then it's struck down and then you've got an enormous amount of hassle trying to unravel that. But I think I wouldn't want to put predictability for the government on the same plane as predictability for the rest of us, which is what is very often thought about as being at the heart of the rule of law. So I think I'm a little bit less worried about life being a bit unpredictable for the Lord Chancellor.
I think we have time for one more question, if it's a short and snappy one. If it's not, we'll just go on. At the back there, thank you.
Hello, my name's Nick and I'm from the Ministry of Justice. Don't worry, this won't get too political. My view of the judgment, and I hope the panel will correct me if I'm wrong, is that in terms of finding the right answer, as you put it, it put a great deal of emphasis on the findings of the Joseph Roundtree Foundation and what it was at minimum income necessary to engage in society. To the panel, is this a welcome change to the way in which judges approach polycentric economic questions, and perhaps also for the government in terms of relying on expertise that perhaps they normally can't engage with? Or is it unwelcome in that it succeeds political and legal power to groups that are unaccountable and perhaps don't have their own political agendas?
Want to take that?
Yeah, well, I think it's absolutely right that governments making policy should decide on the basis of all available evidence from wherever it comes, including the Joseph Roundtree Foundation, of course. They then have to make a decision for which they are accountable. What I found troubling about the case was that having come to a decision, rightly or wrongly, and I think it was a bit crude as a matter of fact, the policy, they are then judged by after events, by the fact that it didn't work out the way it might have hoped to have done, and then there was a review of the whole thing, and that was really the foundation of the decision. It led the Supreme Court to conclude that their initial distaste for it was in fact confirmed by the evidence. But I don't think that it's a desirable thing for judges to decide whether or not a fundamental right has been, if they've identified it as such, has been violated by looking at how things turn out. That seems to me a court sitting in judgment on areas that are not legal.
Yeah, I mean, I think that all I would say is that that was one factor among many that was taken into account in the judgment, one piece of evidence among many. I mean, I suppose just by way of a sort of wrap-up point, really, there's been quite a lot of discussion about the effort that was put into the policy, and we've just had the comment that what came out of that might have been a little bit crude. And obviously, there's a risk of us looking back on it and judging it with hindsight, but it does seem to me that quite a lot of quite obvious points were missed, like the fact that many tribunal claims have no monetary value at all, and charging a fee for those was always going to be quite problematic. And so I kind of missed the days when policy making involved green papers and white papers and really genuinely thorough analysis in the best traditions of the civil service, and I think we've lost something recently, and I think that's a shame.
Stephen, that's good.
Well, I don't welcome it as an approach to polycentric issues, because I think, as Lon Fuller in his essay on the limits of adjudication showed, judicial decision making is not apt for polycentric issues. So I agree with Lord Fawkes, is that those evidence questions are questions that are relevant to political decision making, and that's why I think this sort of decision making should be political. I do have a slight pop in my footnote somewhere at the idea of evidence-based policy making, and it is very important when you are making policy to take account of the evidence that's there. But there is a myth around that evidence can tell you what the right policy is. It can sometimes tell you what the wrong policy is, but it can never tell you what the right policy is, because every bit of policy making involves making a judgment about what you want the future to be, how likely it is you think you can achieve it, and what the risks are of doing so. And those are things that some evidence may give you some idea about, but they can never answer completely. In the end, there is a judgment that has to be made. It has to be a political judgment, and people have to be politically accountable for it.
On that forward-looking note, we should join in thanking the panel for a very interesting discussion.